Hi, my name is Diane Weinberg, and I'm the principal of Weinberg Elder Law, located in Sandy Springs, Georgia. You cannot just simply spend randomly for the senior's care. You actually have to have a budget and stick fairly close to that budget. All of the income for the senior can be spent freely on that person's care, no problem. If you need to dive into that person's estate, or their assets, what they own, you actually do need to get court permission. Now, when you first become conservator, you have to file what's called an inventory and asset management plan. And you actually have to file this every year as long as you're conservator. And this contains an inventory, what the senior actually owns. And the asset management plan is the budget for the next year, what their expenses are. And through this budget, you tell the court how you're going to spend the income and how much of the estate you're going to have to sell to meet that senior's needs, if any. Some people have adequate income. Sometimes we've got to dig into the savings to meet their monthly needs. And you have to, again, give this information to a court, and the court should approve the budget. And once the court approves the budget, you're free to take those actions. Now, what happens if you have an unexpected expense? Then you tell the court and you get permission to spend that additional funds. Now, as guardian or conservator, this is very important, you are not responsible personally for the ward's expenses. If you choose to pay for something, that's fine, but you have no legal obligation to pay for it. The ward is responsible, the senior's responsible for all of that senior's expenses. If you want to move the ward in the state, maybe you want to move the senior to a different facility or to be closer to you, whatever the decision is, you always need to, of course, send a change of address to the court. But if you want to move the ward, the senior, out of state, you do need to get permission from the court to do that. So make sure you file that petition. Somebody comes to me, mom's not living at home anymore, I'd like to sell the house, she can't drive, we really need to sell the car. Which is great, and it makes sense, but you have to get court permission. In fact, you really need a completed sale to go to the court and say, Your Honor, and there's a standard form you can file, but you go to the court and say, hey, Your Honor, we'd like to sell the car. We have a buyer who is offering to pay this much. The court will appoint a third person called a guardian ad litem, and the guardian ad litem will assess the sale to determine that it's in the best interest of the ward and the sale is for fair market value. And with the guardian ad litem's approval and the court's approval, then the sale is complete. So any sales of the ward property must be conditional upon the court's approval. The only exception is a yard sale. Of course, we can't anticipate how much a yard sale is going to bring in. In that case, we just get permission from the court to do the yard sale. So those are some of the limits, more common issues that we see in our office. Again, my name is Diane Weinberg. I'm with Weinberg Elder Law. And thank you for spending these few minutes with me today. And have a wonderful rest of your day. Take care.